Over the past few months, the hottest topic by far for healthcare marketers on the provider side has not been AI, but in fact has been the HIPAA guidance put out by OCR. In that guidance, the OCR has basically said that any tracking technology for which the information being tracked goes to a third party that has not signed a BAA or business associate agreements with you could constitute a violation of HIPAA and therefore could be subject to fines. What this has been interpreted as, or commonly referred to, is the pixel problem. Right? Why the people are saying that is because of the Facebook pixel that a lot of organizations have been using to put on their websites to track and interpret and analyze user behavior. A lot of people have been using this pixel for very, I would say, innocent reasons, just simply to track, to see what pages people are looking at and what information they may be looking for, and then perhaps using that information for retargeting ads down the road. Well, a lot of people now, because of the guidance that's come up from OCR, have had to rethink that strategy, with some going completely cold turkey and turning off tracking everywhere on the websites. Others are taking a different approach. On today's program, we welcome Matt Fisher, an attorney who specializes in HIPAA and in healthcare. Matt's a good friend of ours, and I wanted to ask him for his opinion on all of this and kind of dig deeper into the guidance and what healthcare marketers can do about it. Hello and welcome to Swaay.Health, where we explore the latest trends and interesting stories from the brightest minds in healthcare marketing. I'm Colin Hung, and joining me on the program today is Matt Fisher, friend and attorney. We're going to talk about the HIPAA guidance that's come out from OCR. I hope you enjoy our conversation. Matt, welcome to the program.
Hey, Colin, I'm happy to be joining you. It's nice to be able to chat and hopefully provide some useful information today.
Yeah, I mean, this is kind of the first time we've officially done this with you, even though you've been a longtime friend of the Swaay.Health community and you've been to a few of our events. So this is kind of going to be fun to have you here imparting some insights and knowledge to us.
Yeah, no, as I said, I'm happy to do it, and happy to also keep reminding folks that legal perspectives and legal advice doesn't have to be scary. Everyone can get along very well. We can all be friends and help each other out.
Yeah, I mean, you got to be honest, right? Legal and marketing usually don't go together, and usually when they do, that means somebody's in trouble. Usually marketing, right? But today we're going to talk about the hot topic of the moment, especially on the provider side of marketing, which is, of course, the whole pixel issue and HIPAA violations that could be happening. But before we dive in deep into sort of the interpretation of that, Matt, you did some reading, you did your homework. Can you give us your opinion, not legal opinion, but just sort of a recap of what that really is? What is all this hubbub about?
Yeah, so, and I guess, maybe it does help to level set, what do we mean by pixel tracking or the tracking technologies? And, I am certainly not a technology expert. I like to dabble on that side. And, oftentimes I find I understand a little bit better than most other attorneys, but that's probably not saying too much on that front. But, as I said, probably just explaining exactly what that means. And you can kind of find, I think, a pretty comprehensive, easy to understand definition actually within the guidance from the Office for Civil Rights, which kind of to pick up on what you were saying is also a lot of the reason that we're talking about this right now. So with all of that, tracking technology is can be embedded in the code on a website, can be embedded in the code in a mobile application. But it's really code that's picking up on behavior and activity as someone interacts with, again, whether a website or using a mobile application. So it can be recording certain types of information about you. It might be, if you're entering it, or it might automatically pick up your IP address, your device identifier, your geolocation information. Kind of, it can be configured in a number of different ways. So, we can talk about this in a little bit more depth because it definitely will impact the legal analysis at least. But the choices that you make and what information you want to collect and how you want to collect it and then where it's going to go are all going to impact where you stand, whether you're in a safety zone under HIPAA, a gray zone, or a clear danger zone. Um, but so that's kind of the baseline of the tracking technology. And then the reason it has become, such a hot button topic, which I suspect a lot of the listeners probably know, is, I believe it came out through independent research that was then published in an article that pretty much every hospital out there had tracking technology, and in most cases, Metapixel. In this case, Meta not referring to something large or overarching, but Meta, the company formerly known as Facebook, that was producing this particular tool. But as I said, almost every hospital out there had it on their website, and it could have been in many different locations. So it could have been in they're generally publicly facing side of the website, so that probably that main page that we all go to if we're searching for a place, or in some instances it was behind a login, so it might have been when a patient was accessing their patient portal, the tracking technology was still in there even behind that login, which is certainly a questionable practice. But what it turned out is that was all included, and then it turned out that that tracking technology was doing arguably exactly what it should have been, which was capturing the data and then sending it to the company that was running that particular tool. And that's kind of where you start running into a lot of the questions and the complications. So again, very brief, hopefully non-technical background on what we actually mean by tracking technology. And that's probably how I'll keep referring to it as tracking technology, just to, I guess, be consistent with how OCR, or the Office for Civil Rights, refers to it in its guidance. And so I guess I'll take a pause there and see if there's other questions you want to dive into, or I can then just kind of start getting into what the guidance was from OCR.
Yeah, no, and if I was just to paraphrase that, and again, I know for most of the people who are listening and watching this who are from a provider, they're probably going, "Oh, I know this stuff," because they've already had to figure this part out. But for those that are on the health IT side, this is kind of why I wanted you to cover it, because we may not be as familiar with it because it doesn't impact as much of what we do on the B2B side. But the way I understand it and the way you've just described it, on the B2B side, we use these tracking technologies all the time, and mostly for the purposes of doing what we call retargeting ads, right? So you go to someone's website, it's got some tracking technology there. It knows now that it doesn't maybe necessarily know who you are, because I haven't self-identified myself to that company, but it knows that I was maybe interested in that company's offerings. Now, in the case of a hospital, it might know that maybe I was looking at a smoking cessation program, or maybe I was looking at a particular type of specialty on that hospital's site because the tracking technology is there. And now when I go somewhere else, like a Facebook or YouTube or something like that, it knows that I was there. And so therefore it will give me an ad that maybe is relevant to what I had been. Pretty innocuous, right? I mean, before. But I think what we're saying is the guidance is saying that actually may not be kosher, and we are now being asked to look at it. But that's the kind of technology that we're talking about, right? Like from a B2B side, we do this all the time.
Yeah, no, exactly. And it's, as you said, fairly innocuous, at least from the business perspective. And I think that doesn't get into the broader questions we have around privacy, where you have all these kind of policy discussions arising around privacy. We won't dive into that today, but I think that's a different component to it. But what's happening in healthcare is kind of, to some degree, a microcosm of that. Because unfortunately, there is nothing innocuous in healthcare, especially in the U.S., where it is such a regulated industry, and you have a lot of very nuanced regulations. I think, as you're saying, like what is a practice that's a really good idea, and probably a standard way of figuring out how you're going to find target customers, or be able to raise awareness around your product. You just have to be a lot more careful around how you're going to do that in healthcare. And the reason why you have to start being a lot more careful right now is, after all of the headlines that arose about tracking technology, you started to see serial class action lawsuits filed against all of these health, or a lot of these different health systems. So the class actions generally took the approach of, you had this tracking technology, it was taking our personal information. You were allowing third parties to look at it, or you were selling or using it to target advertisements or marketing. We weren't aware of what was happening. So, those class actions in most likelihood involve state level claims. So premising on an invasion of privacy or breach of contract or similar types of actions under state law. Even though we're going to talk about HIPAA, the reason you won't see a claim of action under HIPAA is because, just to remind everyone, there is no private right of action under HIPAA. That means an individual, if there's a violation, can't sue and claim damages that their HIPAA rights were violated, because the law just doesn't include that as an option. However, HIPAA can still form in some states. That's kind of the standard that is used to determine if a violation of state law occurred. So when all that started happening, there was arguably an outcry of, what are we supposed to do here? What is allowed? What's not allowed? Where are some of the lines? So the Office for Civil Rights waded into that debate and issued fairly detailed guidance around tracking technologies and what OCR views is appropriate or questionable behavior. So before we kind of dive into what that guidance is, one of the key points to keep in mind is it's just guidance. It didn't go through a formal rulemaking process, so that means it's not really binding precedent. So OCR will certainly lean on this guidance and say that this is how it is going to interpret the HIPAA statute and the regulations, but it doesn't carry the same weight of authority as a fully promulgated rule, which would go through a notice and comment period and then finalization. This is kind of falls into a category that on the legal side we call sub-regulatory guidance. So it's kind of a bit stronger than kind of an informational piece, because it kind of gives you insight into the thinking of what the agency was going to do, but you have room to fight on it because it can't rest on it in court if you got to that stage. So what the guidance says, though, is it's trying to take in my point of view, a really aggressive stance of, if you read it at its most generous, saying that any information that's collected by a tracking technology on a hospital website could potentially be protected health information. Although the first step to it is saying it's IIHI, so individually identifiable health information. For all intents and purposes, they're the same thing. It's just PHI then goes into a step further of who's collecting it, and kind of where it falls within. But for all intents and purposes, it's talking about information that relates to the past, present, or future medical condition or services or care received by an individual. And it's kind of that future part that OCR rests a lot on, about why it's trying to say that most of the information or a lot of the information that could be captured by tracking technology could qualify as IIHI and then PHI. In one of the examples it gives, and this actually goes exactly to one of the things you said, Colin, is it's trying to say you go to a hospital website and you're looking up about a particular service. I'll pick up on smoking cessation because I heard you say that one. So a user goes to the website, the tracking technology, maybe it captures that the person went to that page, different links that they clicked on, and their IP address, and other information about the nature of their behavior in interacting with the website. OCR is trying to interpret that might be enough to qualify as PHI and be subject to the protections under HIPAA. So that's kind of the first part of it, is defining what scope of information could be PHI. So to just put potentially a nice little cap on it, is OCR wants to say almost every information that tracking technology captures could be PHI, and even seems to go so far as to say is most likely PHI, and doesn't leave much room for it to not be PHI. So then the next part of it is, who's collecting that information that's generated by the tracking technology? Is it going to that third party that runs the tracking technology, or does it stay with the hospital, or the healthcare organization that it has it hosted within its website? If it stays within the hospital and no third party sees it, you're probably going to be okay, because now it's fully within your control. You're not allowing anyone else to see it, and as long as you've got appropriate privacy and security protections around it that you would have around your other systems, you're on pretty solid footing. The bigger question is if it goes to a third party. Because remember, under HIPAA, if you have a third party providing services on your behalf and they're going to receive PHI on your behalf, that makes them a business associate under the regulations. And if they're a business associate, then they need to sign a business associate agreement and also comply with the applicable parts of HIPAA, typically laid out in that BAA, but shorthand, it's the security rule and components of the privacy rule. The problem with a lot of the tracking technology companies is they could care less about that. They're not it's not within their scope of business, I would say, to put it generously. So think like Facebook, like they're a public social media company. They're not going to be worried about the nuances of HIPAA because working within the healthcare field is not their primary line of business. And even Google, with like Google Analytics, my understanding is that is outside the scope of their services under like the workspace suite that they will subject to a business associate agreement. So, again, it's probably because a lot of that information is useful for the running of their core businesses, and they're going to want to try and take advantage of it. So if you're using tracking technology created by one of those companies and it's capturing information that's PHI, absent a business associate agreement, that's going to be a very dangerous place to be, because that's going to make an easy case for OCR to assert that you have a violation. And even if you can successfully argue it's not a violation, that's going to take a lot of time and money to get to that point. So if you're capturing information that's PHI, then maybe you turn to a company that is willing to sign a business associate agreement and create and store and interact with your information in a manner that's going to be compliant. So it's, there are definitely ways to get there. You just have to kind of think through the different options and then evaluate the information. So that's kind of the quick lay of the land from the OCR perspective.
So again, just to put it in my head, what OCR is saying is that by you capturing information, that in itself is okay. It's just who is going to receive it. If you're going to use it yourself as the organization, as the hospital, you're probably okay as long as you have, as you said, protections that you normally would have around all your other systems, like the portal, like your EHR, and so forth. And that's because you're taking all that tracking information and using it to do your own marketing directly, what we call first-party data, right? Like that's first-party data. But as soon as you take that data and maybe give it to a third party, because if you're using Google's analytics, or if you're using the Meta Facebook pixel, that goes to those companies, and those companies have not signed a BAA with you. Therefore, you, under the eye of OCR, would be in violation of the HIPAA.
Yeah, exactly. And then it depends on, is the information you're collecting, is that PHI? So
Right.
that's now where you start getting into a lot of the nuance and where there is, I guess I'll say, discontent with that guidance. The American Hospital Association came out with a position statement where asked OCR to rescind the guidance, and it focused a lot on the view of IP address by OCR within the guidance. I think there is a large degree of common sense accuracy in the way the AHA talks about it, which is just knowing someone's IP address, that they came to our general website. That's really hard to say that that's going to be identifiable against a person in connection with their actual healthcare. Because it's, I kind of like the argument that the AHA put into their letter, which is even the CDC is telling people go to hospital or health system websites to get accurate information about different health conditions. So just because, I go to a website and look up, whether it be information about, say, COVID, or even a surgical procedure, doesn't mean I'm actually going to that hospital or system for that procedure. Maybe I just know the Mayo Clinic, to pick on one, is a very well-regarded, well-respected organization, and I'm going to trust their information, and maybe I can find it more easily than on my local system's website. arguably OCR is trying to say that, if you read their guidance, as I said, very broadly, they might say that's enough to say that's PHI, even though, because in the guidance, they do say you don't actually have to have had a relationship or don't have an existing relationship with the
Right.
entity. So it's, makes it really difficult. So that's why, I think you know, taking the time to think through it makes more sense. But, the difficulty around that IP address, and I think the reason it's getting picked on so much is it's not so much that specifically defined as an element that makes something PHI. It's more kind of that inverse, where when you go to the de-identification rule under the privacy rule in HIPAA, IP address is one of the things that has to be removed to be able to make the information de-identified. So I think that's likely where you're getting a lot of the disagreement on the interpretation, because, again, PHI is not usually, well, not usually, it's actually not even explicitly defined in the regulation as having to include certain elements. It's just very broadly defined. But as I said, when you go to the de-identification part, that's where you kind of start getting a lot of references to, oh, these are the elements of what PHI is, because it tells you all the things that would need to be removed to make something de-identified. But I think it's, you have to, if you're looking at the information that's being collected, you have to, I think, make an assessment. Does this make it so it's someone's identifiable? And, is it relating to their actual condition? So that's why I think you're going to start to see a lot of kind of facts and circumstances arguments around whether or not particular information constitutes PHI. And then kind of carrying that another step further, I think I mentioned there's been a number of different lawsuits filed against the systems. In one case, a judge in the Northern District of Illinois, so this is a federal district court in Illinois, in ruling on a partial motion or partially granting a motion to dismiss. So that means the judge approved the certain claims being removed from the lawsuit because there was no justifiable basis under the complaint as it was written. Doesn't mean it wasn't, there wasn't a way to submit it that it could proceed. Just under the facts given, it wasn't enough. And kind of the judge focused on that broad definition of IHI in the guidance. And, there is a viewpoint that the judge was saying OCR went too far. So, again, that kind of goes back to the point that I made, which is the guidance is not binding. It's just a kind of a notice of how they intend to interpret. And that gives the judge, as happened in this particular case, the opportunity to say, no, that's no good. This is how I read the statute, how I read the regulations, and how I'm going to interpret the actual letter of the law. And the guidance is not that.
So I guess you could say, you could roll the dice, right, and kind of hope that OCR changes its mind, revises the guidance, listens to the AHA and others who have come forward to say, hey, this is a little bit too far, right? We get what you're trying to do, but you've gone too far this way. Bring it back a little bit. But that may take a while as things wind its way through the various levels, of course. So if I was a healthcare marketer, though, like what should I be doing here? Should I start and just go, hey, I got to turn all these things off, go cold turkey here? Should I keep doing what I'm doing, but maybe start to think about more carefully, maybe not applying the pixel everywhere? Like what would an advisable, or maybe an advisable risk reduction step be for an organization?
Yeah, no, I think there's kind of a few different components to the way you can reduce that risk. The first is evaluating and making sure you actually understand what tools are being deployed where, and where the information that's being gathered is being sent. Because it seemed like too often part of the problem was the organization didn't actually know that the tracking technology was even on its website. So kind of the head in the sand approach is definitely not going to do you any favors. Once you actually identify where the technology is, then figure out which technology is being utilized, who's running it, what information is being collected, and where is that information being sent. Arguably, that's going to form the core basis of actually being able to do the risk analysis around that technology. And a risk analysis is the fundamental piece of being able to actually determine what your security posture is under HIPAA. So once you've figured all of that out, then you can kind of stratify or attempt to stratify the risk around the utilization of it. So let's use just an egregious example. You're using Metapixel, it's collecting, you know, all available information under it. So it could become very identifiable, and you have it deployed both on the public side of your website and inside your patient portal. If you want to reduce your risk, get it out of your patient portal, because there's no question that that is going to be capturing PHI, and it's now going to be sending it to an organization that is very well known not to sign a BAA. If it's on the public side, maybe think about where you're deploying it. Is it just on the main page, so it's collecting information about anybody passing by? Is it, maybe you have a login page where someone who doesn't have their portal account yet goes and starts entering information to create their account? If it's there and it's capturing that, danger zone, or clearer danger zone. The completely public side, OCR again seems to say that's a danger zone. I think that's a harder argument for OCR to win. But again, do you really want to have to be fighting them? Let's go to a different example of, you have you're using a tracking technology created by a company where you have a business associate agreement in place with them. There you have much more freedom to put it pretty much anywhere because you're taking the steps to comply. But what if you're kind of in that middle zone where you're not sure what, or maybe you identify what you have, and probably more in all likelihood, you've got the technology from a company that's not going to sign a BA, but you still want to be able to utilize tracking technology everywhere.
Mm-hmm.
Maybe transition to a company that will sign a BAA. So that way you can step into a zone where you're demonstrating you're aware of the requirements under HIPAA and you're taking the appropriate steps to do what you should be doing to comply. Or kind of divide it, where again, if you want the tracking technology in an area where it's a much clearer argument that PHI is being collected, switch to a company that will comply or is complying. And then on the public side, maybe limit the scope of what's being collected and still, kind of arguably roll the dice a little bit with call it a non-healthcare savvy vendor. But the other consideration to help reduce risk is, as I said, part of that analysis is going to be determining what information is actually being collected by the tracking technology. Do you actually need to be collecting every single bit of information that's possible under that tracking technology? I think you probably want to evaluate what's the true purpose of having it, and how are you going to use that to advance, a business goal of the system or the hospital. And if, as you go through that, you say, hey, maybe I'll only need a quarter of that potential information. Now you're collecting less potentially identifiable information. You're storing less potentially personal information. And that at a baseline is going to reduce your overall risk, if, God forbid, a breach happens. But, also maybe you can start moving into and collecting only information that you have a much stronger argument of saying is not identifiable and is truly maybe anonymous, or just general behavioral information that couldn't tie to a specific person. So, those are kind of a few steps that can be taken to help start reducing the risk. And, I think should really emphasize, you don't need to go cold turkey unless you're just trying to stay using technology in a manner that's, even under a conservative reading of the guidance, is clearly going to pose a significant amount of potential liability.
Yeah, I think I like what you said there, Matt. I mean, we forget that, collecting this data was convenient, right? We just stick the pixel on there, stick the tracking technology on there, and then lo and behold, you could get some really useful information. And I think a lot of people might have implemented it because one day they were going to use it. Right. One day I might do a retargeting campaign. One day I might do this, or hey, this analytics that I get from somebody like a Google, they're not the only ones, but like a Google, was kind of helpful in maybe the initial design considerations of my website, right? But they sort of left it there because it didn't cost anything, right? And now it's just been sitting there. I think those are going back to what you said, like you really need to evaluate, okay, do you even need that tracking pixel? Is it serving a business purpose? Because if it isn't, then very easy, just turn it off because you don't need it, right? If it's a nice to have, consider turning it off because you don't need it. But if it is providing a business purpose, like it is driving some patient volume to you, then I like what you said there as well. To say, okay, well, what information do you need? Do you just need the geo and nothing else? Do you even need the geo at all? If all you need to do is just retarget them with what they were interested in, and all I have is the fact that you came to my site, I don't know who you are, where you are, anything else, but I know you are somewhat interested in this program. Maybe I might serve up something to you down there on somewhere else. You could maybe look at that and go, that's an acceptable risk for you, right? Like as an organization. But yeah, I mean, I have heard a lot of organizations that initially, when this guidance came out, they went cold turkey, like they literally turned this right off, and then have slowly started to add it back on, or slowly started to adopt new technologies from people who were willing to sign a BAA, typically smaller companies. Um, but I still think a lot of them have taken the let's just wait and see approach. And what I'm hearing from you is that's can be very dangerous, especially if you're using that tracking technology behind on your portal.
Yes, yeah, no, I mean, I think anytime you're using tracking technology in a place where it's in a portal behind a login, that's going to be the area the highest risk. But then to your point, it's I think the common reaction whenever there's enforcement action or public pronouncements of red flagging an issue is to just stop that practice altogether. But there's usually a way to figure out how you can do it in a way that's going to comply. It's kind of the way I always like to describe it is healthcare makes it more difficult, and you're going to follow a path that's definitely not a straight line, and definitely not the one you were expecting. But I think if you take a very thoughtful and considerate approach to what you'd like to do, you can typically find a way to be able to get there and achieve your business purpose in a way that also satisfies your obligations under the regulations.
I really like that. And again, going back to it, as marketers, we sometimes forget that we have these tools deployed, right? So through no malfeasance or no purpose, you just everyone would, you're instructed when you put together websites, oh, you put this pixel on there because it allows you to do some tracking and some analytics. But how often do we go back and revisit them? And I think when I've spoken to at least some folks at the various shows that have been covering this from an agency standpoint, but also from an advisor consultant standpoint, a lot of people are taking this opportunity to kind of go, it's time now, do an audit of all this tracking, right? Because and take the opportunity to kind of really see, as a marketing organization or as a healthcare organization, what are you tracking and why, right? It's about time we do that, and therefore, and to reduce your risk overall. Just because OCR has come up with it doesn't mean that this is the only thing they're going to be looking at. And I think you should take the opportunity to kind of make sure that what you're collecting makes sense, right?
Yeah, no, I very much agree with that. And it's, I think it's always, no matter what area of operations you're talking about, it's always a good idea to continually revisit and reevaluate what you're doing, why you're doing, and how you're doing it. Even if the guidance hasn't changed, maybe the technology has evolved and you can do something more efficiently, or you can find a tool that's going to achieve your purpose better. You never know what you're going to find, but you have to know what the current operation is. And again, from that risk analysis perspective, if it's collecting information, you absolutely need to be evaluating it, because if you're not, you're going to just create some blind spots in your compliance program.
Right. Yeah. Again, if anything, this guidance has opened or reopened people's eyes to the risks that are involved with collecting information. Right. I mean, I wouldn't say marketing has not been aware of this, because HIPAA has always been on the minds of most people that we talk to. But sometimes, we get caught up in the whole patient acquisition thing. We get caught up in some of the things we're doing to analyze the effectiveness of the websites that we put out. And sometimes we forget that this is going to a third party, of which we don't have a BAA signed. So this was unfortunately a cold a cold ice bucket full of water splashed in the face kind of reminder, but it is a reminder that, hey, we should really be thinking about this a little more proactively.
Yeah, and sometimes that bucket of cold water isn't a bad thing, because arguably better to get that bucket of cold water telling you to reevaluate stuff than to get the letter in the mail saying you're being fined X number of thousands or millions of dollars because of the issue.
Yeah. And I think, again, I go back to something you started off by saying, this didn't start because OCR wanted to do something. This started because all of a sudden there were some class actions that were starting to crop up, and OCR was asked to kind of render an opinion, and they did, and they basically erred on the side of, okay, well, we don't want our members and we don't want the hospitals to be sued left, right, and center. So, hey, this is how we're going to interpret this. And so they swung the pendulum quite far the one way in order to, give advice that would protect the organization. But in doing so, they've kind of hampered one of the most common things that hospitals can do to be more effective at acquiring new patients.
Yeah, no, I think that's a good way to put it, which is, it's maybe if the issue had been presented to OCR, it still would have come out with something. But the fact that it started first with, investigative journalism and, big headlines, and then subsequent numerous class action lawsuits, something had to occur, and issuing guidance of this nature was the fastest thing that could be done, and also arguably left the agency with the greatest amount of flexibility, because again, even itself is not bound by it, because agencies can update and modify guidance as either regulations change or experience with the real world kind of evolves.
Matt, you've shared a lot of great information here. I'm sure other people are going to have lots of questions that we didn't cover in this in this program. Where can people go to connect with you or find out more?
Yeah, so usually on social media, Twitter at Matt_R_Fisher, although I guess it's X now. For folks who like to use Slack, I'm in the health tech nerds community. I am on Blue Sky now, so at Health Law Matt. I am honestly not yet sure how to find myself there, because it took a while to actually get in. And then blogging as well, so that's Health Law Pulse, and also on LinkedIn. So it's, I try to be out there as much as I can, and Noah just kind of reflects a lot of the community.
Amazing, Matt. Well, thank you so much for being on our program today and for kind of giving us your opinion and insights into this topic.
Yeah, no, it's my pleasure to be here, and hope people found some value in it.
Hey, I want to thank Matt for coming on the program with me today. I always love speaking with him, especially because Matt is one of the very few attorneys that I know that really speaks his mind and is not afraid to kind of talk about those gray zones, those areas where, the letter of law may say one thing, but the actual interpretation and implementation of the law may not be exactly as the law was written. So really appreciated that he went there, and also really appreciated the pragmatic advice that he gave for marketers around how you might be able to stratify the risk and not have to go cold turkey. And hey, if you enjoyed this interview as much as I did, please like and subscribe. Also, head on over to Swaay.Health. That's Sway with 2 A's, .health. That's where you'll find more great content like this. I'm Colin Hung. Thanks for being here, and I'll catch you on the next video.